ready for that conference, where they're going to lay ground to the rules or whatever it is that we're going to see once those sanctions begin tomorrow. Now, to know the number of lawyers who will be assigned in each particular sanction. We're going to know the rules that they're going to follow. We're also going to know any other orders as pertains these petitions. By the way, now they look like there are already 8, and any other consolidation that's going to come today. Now, what we do know is that the Supreme Court under law have only up to Tuesday next week then to come up and tell us what then this would mean for the 9th August general election. Now, let's put that into perspective. And joining me in the studio this morning is Timothy Mwendwa, who's the advocate of the High Court. Timothy, how are you doing, sir?
Fine, thank you. Good morning.
Good morning. Just let's understand this conference that's going to happen today. And under that, we've seen exactly what the Supreme Court wants to do. They said they're going to lay the ground for the hearing of those petitions. They're going to assign particular numbers of lawyers to each particular side in as regards the petitioners. They're also going to lay any rule and consolidate the petitions so they're able then to come up to a ruling as of Wednesday, actually Tuesday next week. Is there anything that we're going to expect today from the Supreme Court that will be a surprise as far as this petition is concerned?
Yes. What Supreme Court, I can't predict, but what we anticipate is that they're going to change the way of the rules that have never been there before. Mm-hmm. Previously, we never used to have a set of limit of lawyers inside the court. But this time round, I expect that number from 4 to increase. Thereafter, I expect strict rules that we've never seen before.
Yes.
And also, I expect decorum before the court. Mm-hmm. Yes.
I like the way you're saying strict rules that we've never seen before. What is very special about these particular petitions that would demand strict rules within the Supreme Court?
Due to time, yes. Because the petition should be heard and determined within 14 days after declaration of the results. Mm-hmm. Counting 14 days from last week Monday, whereby that was the day when it was the last deadline for filing.
Yes.
Now that takes it to next week on Monday. By midnight, they should have declared the results. If not, it can be challenged in court as the decision is unconstitutional, and the president, incumbent president, his term will extend.
Yes. Also interesting, Timothy, is that this time around we have 8 petitions so far. They started with 9, now we're back to 8. When they're saying we're going to consolidate the petitions that we have as the Supreme Court, are we going to see them squeeze these petitions further, maybe into a lesser number? That consolidation, what exactly do they mean by that?
Consolidation generally means they consolidate the issues together, okay, and then they have, let's say, a lead file. I do think the leading file in this matter will be Raila's petition number E005 of 2022.
Yes.
Is one that is going to be the leading because it has raised so many issues, unlike the other petitions. And then there are some issues that have been raised in various petitions that are similar, or they're just the same. So I think they're going to consolidate those issues together and they be heard together by the judges.
Yes. But when we talk about the assigning of the lawyers in these particular petitions, are they looking at the petitioners? Because we do understand there are 8, and then assign a specific numbers of lawyers to these petitioners. Is that exactly what the interpretation means?
I think when the Honorable Chief Registrar was talking,
yes,
I think she meant 4 lawyers each party. But I think the court is going to review that because it is not of justice giving, for example, a president-elect 4 lawyers, yet he's battling, each petitioner has 4 lawyers, so do 4 times 8. That's 32 lawyers against 4 lawyers. They'll be too much fatigued to cross-examine and to follow the court process.
Yes. Look at the limitation of the time that these particular cases are going into. What we do understand is that by Monday midnight, at least, we should have known what this petition would have in the offering for Kenyans. When you look at the number of these petitions, yes, they're going to come and tell us we're trying to consolidate it and give you a framework for the hearing of these particular cases. When you have so many petitions and you have a limited time at the Supreme Court then to come up with a decision on it, does it interfere with how the judgment process is going to be, or that is now left to the lawyers of each parties to come out and defend their particular petitions as good as they can?
It is upon the lawyers to come and defend, because
Timothy, how much of a task is that?
it is each lawyer is equivalent to the task given. Yes. Because as you can see, the judges are qualified. Some of them have been there since 2013 in the first petition.
Yes.
Now we have our CJ who transitioned there, and the Honorable the Honorable Judge Ouko, who was the President of the Court of Appeal. These are competent judges who have experience and they know. So I think it is upon the lawyers to prove their case, whether the petitioner's side, whether the respondent's side, and we look for justice before our Supreme Court judges.
When I look at the number of particular lawyers that these petitions were signed to, I mean, we saw some of them have even 54 lawyers, 52 lawyers that have been assigned to these particular cases, and then at the end of the day, you only have 4 presenting. Does that take away the juice out of these cases? Are we going to see them present?
No, it does not take the juice. What happens is this. There's some, in that batch of 50 lawyers,
yes,
there's some lawyers whose work is just to do research.
Okay.
There's some lawyers whose work is just to put in the facts correctly. There's some most senior lawyers, their work is to litigate in court due to the experience. For example, you saw during the 2017 presidential election, you saw our seniors like Mwite. He was the one litigating. You don't expect a senior counsel like him to do most of the drafting work.
Yes.
Yes. So due to experience, he's left for the part for litigation, and yet the young lawyers do the drafting, and it also depends with your passion. There are some lawyers whose passion is just typing facts, putting them correctly, putting case laws, doing good research, but there are others whose work, when they come to court, they litigate very well.
Yes, pretty much. Here's the thing, even as we speak right now, there are some submissions that have already been made to the Supreme Court. Ruto, as of yesterday, yes, is now calling for the Supreme Court not to allow the 6 commissioners who were dissented with Wafula Chebukati on that results, not to present at the court. Remember, Azimio Coalition is riding on their presentations as the basis of presenting their case. Would you expect that the Supreme Court is going to rule on that today when they're going to consolidate these matters? Do you expect them to be thrown out, or they're part and parcel of this particular case?
I think Ruto has not made submissions.
Yes.
What he made is an application.
It's an application to the Supreme Court, isn't it? Yeah.
Yes, an application to the Supreme Court. And the application he has made an application so that the commissioners do not act independently as respondents, but they act as a commission.
Is that difficult going by what is going on in that commission right now?
It is now upon his lawyers to prove before the court,
yes,
that a commission is a statutory and corporate body established under the Constitution and also established under the IBC Act, so that they are able to work uniformly and not as split as they are. Let me take you back.
Yes.
Recently, before these elections that were announced yesterday, you saw the 7 commissioners met at Bomas. All of them together. There was even some memes about the vice chair and the chair that were trending online. So they need to be together in the petition for the goodwill of Kenyans.
Hold on. Timothy, you've got to understand this particular one. Is this Ruto trying to say that indeed this result is for this particular commission? Is that what it is? But then is the law not clear that the person who delivers this result, the national returning officer, is Wafula Chebukati, not the commissioners? Because the commissioners might be absent from the delivery of the results. The announcement of that particular result is the sole responsibility of the national returning officer, who's Wafula Chebukati. He did his part. This particular application by Ruto now, is it not difficult when all these commissioners are saying, well, we do not agree with this particular result?
Let me refer you back to the Constitution.
Yes.
Our Constitution clearly says this, that before a presidential election results are announced, the commission is going to make a decision. Thereafter, the national returning officer, who is the chairman of the commission, is going to announce. Okay? That is what Chebukati did. Constitutionally, he did his mandate.
Despite what the other commissioners said later, that indeed, whatever he announced was not part of the decision that we met together. In fact, what they're saying, Timothy, is that we never made a decision on this. Yes.
I think they should produce that in court, at the Supreme Court, so that the judges will determine it.
But then Ruto doesn't want that now. He's saying, well, they should not act independently. Is it going to be difficult for the Supreme Court to grant him that wish, when in reality then the commissioners will come out and say, well, you see, the court says that we should make that decision together. But as far as we are concerned, he didn't make it. We didn't make it together.
I think that's upon the court now to decide on the merit of the application, and also in regards to, because if this application is merited, it will have an impact at the judgment.
Yes. Here's the thing. Just before we take a tiny break and continue with this particular conversation, how hard is it going to be when indeed, as Emir said, you see the basis of their presentation is essentially more than half of our petition?
Now, the basis of the petition of Azimio will literally rely on the evidence. Some of the evidence that have been discussed out here, they are not admissible before the court. That's something that we are going to look at. The other thing we are going to look at is, has the case provided for any irregularity that happened during the election? An example of an irregularity is we have bribery, voter bribery, we have ballot stuffing, we have manipulation of the system, electoral system, and anything that was done contrary to the law. If they're going to prove that before the Supreme Court, then they'll carry the day.
That's it. Pretty much, Timothy. I would like us to take a tiny little break, because once we come back, that's when now it gets a bit interesting, because this particular evidence that this commissioners are saying, we do have this one and we are ready to present it in a court of law. You see, Tuju has been trending as well. The other commissioners also now are on the spotlight for trending, having meetings and really trying to influence the results. How heavy is that evidence? And we're going to scratch on it so we can see exactly what we expect once that case then officially begins. We take a short break right here at Look Up TV. Once we come back, this conversation does continue at Look Up TV across all your social media platforms. Talk to us. Welcome back. Oof, there's a lot to go through, by the way, as regards the conference that is going to go down today, and we shall promise that is going to be live at Lookup TV. Let me introduce to the conversation another advocate, to another legal mind, really, to the conversation. Let's talk about legal minds today, because we do have Elkanah Mugaka, who's a legal expert. Elkanah, how are you doing, sir?
Thank you.
Welcome to the conversation. Fantastic. I'm still with Timothy Mwendo, who is an advocate of the High Court. Elkanah, let me begin with you as well, because we've really scratched the surface with Timothy. Interesting this time around that this particular petition presents something that we've not seen in the country as regards election petitions. So we have a lot of petitions. We have the same time that has been awarded to the High Court to go through the entire of these petitions and deliver that judgment by Monday, regardless of the number of petitions. Now, we're going to look at that particular area that the High Court did speak about, consolidation of these particular petitions. Is that going to be the highlight of the day? Because they have to go through the entirety of those petitions and give us a ruling by Monday next week.
Pre-trial conference,
yes,
which is what we're doing today, covers all these things. Kenyans know how the judiciary works. A judge and a magistrate can handle up to 50 cases per day. So this is not something new to them. 9 petitions and 20 interlocutory applications will not face a judge, because this is a small number of matters in comparison to the number of matters they are faced with every morning when they are told there are 100 clients sitting outside the courtroom. Please come and assist all of us.
So you're saying this is going to be just a normal day in the office?
Yes, because what people are not seeing is that this is the only matter that the Supreme Court is handling. There are 9 petitions, yes, but it is concerning one election.
Yes.
So all the issues that are being raised are just about the different aspects of one event that occurred on one day. So do not be so concerned on how many people are rushing to court.
Yes.
These applications and these petitions will all be put together within at least 24 hours.
Yes.
And then once that is done, hearing will kick off. And this is not just one judge, this is 7 judges.
Yes.
So if they were dealing with 50 matters each, they would have all handled about 250 matters in the same time frame.
Seen members of your legal community already looking at this particular issue of assigning a specific number of lawyers to each petition we're going to present then. Is that going to be an issue in the sense of some people would wish that they have more lawyers are going to defend them at the Supreme Court?
What happens in these issues is that once all lawyers have been hired, we all have our different roles. There are those who are going to be drafting documents. There are those who are going to be doing research. It doesn't have to be every advocate who has been enlisted to this case is presenting the case in court. There will be a lead counsel,
yes,
much like is in the previous petitions in 2017 and 2013. And those advocates will be the ones carrying the information the rest of us are collecting to present to the Supreme Court.
Yes, pretty much. Maybe I should have started with you this, because we did touch on that one with Timothy earlier on. How special, how unique is this particular petition that the Supreme Court is looking at? Because indeed, the details are the ones that we're looking at, in the sense of you have commissioners who are also going to testify before the Supreme Court as to how they do not agree with the result that has been presented in front of the Supreme Court. Is that where it starts to become special?
We live in a very curious time where the IEBC, who are meant to be respondents, now seem to have come to become also the petitioners. On one side, we have IEBC led by Chebukati, who are the respondents, answering to why they made an announcement. On the other side, you have
another IEBC
who want to be petitioners, as though they are also running for election. So we live in a very curious time.
Yes.
And since the Constitution was only promulgated less than 10, 12 years ago, we have not had a chance to create jurisprudence yeah, precedents and understanding of how that constitution and how those commissions properly work.
Yes.
You will also understand that we have been crying and drumming that the IEBC commissioners should have been employed or appointed 3-4 years ago. We drummed that all over. No one was listening. They only came and rushed people in last year towards the tail end. People who have only been in office for 11 months are expected to know how to run an entire presidential election. It cannot happen. So we do live in a curious time, but
yes.
This is why lawyers and judges exist. We now take the constitution, interpret it, and create jurisprudence so that the next time
yes.
the elections are coming up in 2027 or any by-elections coming so forth, Kenyans will already have an understanding of how IEBC should work,
yes.
and the IEBC commissioners who will then be employed next will understand on what their roles are supposed to be, especially as concerns the quorum.
Yes, yes, pretty much. Now, just before I cross over to Timothy, because then I think if I ask you this, and we'll be all on the same page so we can carry on with this conversation. The law is clear, and I do not know where we are getting it wrong, or where it's not black and white. Wafula Chebukati is National Returning Officer. That one everybody does know. But then the question becomes, what is the role of the other 6 commissioners as regards the result that Wafula Chebukati presents? Because as we speak, Ruto has already made an application to the Supreme Court to stop the other 6 commissioners who want to present in front of the Supreme Court as to why they do not want to agree with that result, because Ruto is essentially saying, you guys are the commissioners and the law is clear, you need to act together. Is the law clear on who the commissioners are?
There is what we call the letter of the law,
yes,
as opposed to the spirit of the law. What am I saying? I am trying to put that when we look at IEBC, the kind of sideshows we are being treated to in public is bringing down the value of that office. IEBC should be looked at the way you look at a judge or a judiciary. That is a place where the business of professionals is supposed to be conducted. And once a role has been assigned to someone, you should respect that role. You now find that Chebukati came to make an announcement while his head was shining. You did not know how much stress he was going in the background.
Yes.
I almost feel like he's a hero because he managed to weather that storm till the last day, till everything now went, the train went off the rails. So I need Kenyans to understand that when you look at IEBC, when you look at Mr. Chebukati, when you look at the sideshows and the people who are throwing chairs at bombers and trying to cause issues, that is not how the IEBC should be run. They are the neutral party who assists the electorate choose their leaders.
Yes.
A country only runs as a democracy if the offices where those, the institutions where those issues are run are respected. And there has been a lack of respect for the IEBC, especially the chairman, who is constitutionally appointed.
Yes.
Much like the Chief Justice is appointed by the Constitution, much like the President, who they keep saying needs to be appointed by,
as well. Yes.
Through the Constitution.
Yes.
They are all officers from the highest law of the land. And they need to be treated with the same respect. So when Chebukati makes a decision to announce, we should allow him to announce. And if you have any issues to raise, there is now a formal legal process where you go and raise your issues there. Don't pack up and rush to Serena to start causing chaos.
I'll be coming to you on that, because then the other guys were arguing otherwise as well. Now, Timothy, let's pick it up from there now. So, in the event then that the Supreme Court makes a ruling, there are particular observations that we've seen from this petition for the Azimio coalition. They're saying, in fact, after that ruling, whichever way the way it goes, should it go our way and you order for a rerun, then indeed IEBC cannot, in its current state, then be trusted again to conduct an election in the country. If that is granted by the courts, what are Kenyans looking at?
Did you say, you know, in the legal term?
Yes.
My learned friend here can confirm. when you mention a ruling, it's on an application.
Yes.
So are you talking about the application they've made or the whole
The application
petition?
they've made, yes.
Okay. When it comes to the application, I think once a ruling has been made, the court is going to direct on the way forward. But after the hearing, the court is going to make a determination. And the determination is going to be either on three things: either to validate, two, to invalidate, and three, after invalidation, they'll order for a rerun.
Yes.
And that is upon now the court and the evidence before the court. And we are going to, there's a way we Kenyans are known to speculate things.
Yes.
In football, we can speculate, and also in this whole petition, we are going to speculate how it goes after the hearing.
Pretty much.
Yes.
All right. Now, I do understand, by the way, that you're also supposed to participate in whatever is going on in the Supreme Court today. Let me just pick your final sentiments, Timothy, before you step out, isn't it? If you look at the way that we've set ourselves for this particular case that is at the Supreme Court right now, and we expect that it goes to start as from tomorrow, the setup so far of the 8 petitions that we've seen at the Supreme Court, does it speak to how majority of us then do not have trust in the electoral process in the country, or it sort of speaks to the way in which we've understood the constitutional process as regards elections in this country? What does it show?
It has shown that Kenya has grown. It has grown in different ways. The electoral process that we had in 2013, it's different from the one we have in 2022.
Yes.
Mind you, let me take you back. In each 1 year before or 2 years before an election, there has to be an amendment of the electoral laws. I don't know how our politicians feel each other, but they have to go to parliament and correct our laws.
Yes.
Now, when we come to this other side of the divide, the Constitution says that if any person is aggrieved of the presidential results, he or she can petition to the Supreme Court. Any person means even my shosho back in the village can do that. But I think we need now to put what in law we call locus standi on the capacity for you to do a petition.
Yes.
It should not be every Tom, Dick, and Harry should rush to the Supreme Court just because you can raise 1 million of security and 500,000 for filing fees. I think from the next cycle of election, I think there has to be a change on that. And also, I promise you, come 2027, our electoral laws will have changed. The forms, we might even be, I'm expecting even the next cycle, instead of Form 34C, we'll be having Form 34D or E.
Yes.
And, we have grown as a country in regards to electoral laws, and also our jurisprudence has grown. We have seen cases whereby they start from the High Court, gubernatorial, like, for example, the Wajir case, it went up to the Supreme Court, and you saw what was the determination of the Supreme Court. Different from the determination of the presidential election.
Yes.
Yes.
Pretty much. Timothy, at this point, I will allow you then to leave the conversation, because I do know that you're part and parcel of the process that's going on. Let me cross over to you as well, Mogaka, on this particular one. And I want to pick it up from our EBC as well. These commissioners were now in the office and have dissented from the result that Bufula Chebukati did release as a national returning officer. There's an application by Ruto as well that says they're going to act like a commission. And today, hopefully, we're going to expect the final decision on that application. Do you expect that as from today, the Supreme Court is going to start interpreting the law on exactly how the law sees the commission before then they make that ruling on the application for Ruto? And I want you to hold your thought on that. We take a tiny break. Once we come back, we'll be coming back with that particular response. Now, even as we wait for that Supreme Court conference that is going to be a guideline on exactly what we're going to see as from tomorrow, once those supreme sessions begin, on the elections petition, petitions, yes, to be exact, on the 9th August general election. What we do know is that right now, the Supreme Court, by the way, has already rejected 3 applications, including one, President-elect William Ruto's request to bar the Law Society of Kenya, LSK, from being enjoined in the 2022 election petition. What we do know is that the court has also struck out the petition from former Gatundu South Member of Parliament Moses Kuria, together with former Bere South Member of Parliament Geoffrey Kinganyi, who had filed the petition urging the Apex Court to throw out Mr. Odinga's suit on grounds that he was involved in election malpractices. I know we're going to touch on that. Let's begin from this one, from the Law Society of Kenya, LSK. William Ruto did not want them to be enjoined in this petition. He applied to the Supreme Court and told them, can they not be party to this petition? Why did the Supreme Court rule against this one?
The Law Society of Kenya is a watchdog.
Yes.
Its role is to look after the rights of Kenyans, but from the society of all lawyers. If you look at the history of the LSK, it always sides together with the Kenyan National Human Rights Commission and other watchdogs to make sure that a process is free and fair from the side of the legal experts. So if you were to remove them, then they are such a critical party, you would not be able to announce a judgment or deliver a judgment that is agreeable to all parties. Can you imagine a situation where on Tuesday next week, all the lawyers in the country say we do not associate ourselves with whatever the judges have said? It is quite a curious situation that no one would like to be involved in. So the watchdog of the people is the Law Society of Kenya,
yes,
with the LSK president. You saw how vocal the last president was, Nelson Havi, in making sure that the government was kept in check, in making sure that the courts and during the COVID protocols that lawyers were allowed to travel that night to make sure clients being arrested were not being arrested for the wrong reasons, because all these things are a watchdog's duty. So the Law Society of Kenya are a critical party to every public interest case,
yes,
so that they can make sure the interests of Kenyans who need defense against whatever is going on in the side of the petitioners, yes, and the side of the respondents. Because you remember, each side is really protecting their own interests. You cannot say that Dr. Ruto is protecting Raila's interest and the people's interest. You cannot say Raila is protecting Dr. Ruto's interests. Everyone is there to try and win an election, and Kenyans need to have someone who is watching out for them in how that process is being conducted.
Pretty much. So what sort of statements are we going to see from the Law Society of Kenya as this Supreme Court case goes on as from tomorrow?
The Law Society of Kenya will be attending all the matters.
Yes.
And bringing up their commentaries on what they saw during the election,
yes,
whatever irregularities they witnessed themselves, or whatever procedures in court, as we, the legal experts, know how the court should be run on a daily basis, on a day-by-day basis. If there is any misstep on the side of the parties or on the side of the court, we will be able to raise our voice and tell the court, no, this is not the way. Take a step back. We need you to consider this interlocutory application. No, the Attorney General is also is not supposed to be a party. He's supposed to be an ex-official member. You noted that the AG chose to not side,
yes,
to not enjoin himself in the party, despite him also having the similar role, which could be read as him being a loyalist to one or the other side. We are not saying which one. By choosing not, yes, to oppose or do whatever the, yes, statement that he made, I will not paraphrase, he almost appeared as a loyalist. So we need the LSK in court to put checks and boundaries on each party and on the court to make sure that everyone is doing the correct thing in court.
Yes.
Yes.
But let me go to the next one as well, which was interesting, and you might give us some commentary on why you think that the Supreme Court took this out. Now, if you look at Moses Kuria's application, together with former Mbeere South Member of Parliament Geoffrey Kinganye, they are asked the Supreme Court to throw out Raila Amolo Odinga's petition from the Supreme Court, arguing that if you look at the results, yes, indeed, there's evidence from the IEBC portal that there were bit of malpractices from both ends. Then they came in and said, on that basis, then, it doesn't mean that the election was barely stolen. It means that there were mistakes in this election that occurred from each end, so throw it out. What do you think the Supreme Court looked at it and then said, this doesn't make sense?
In legal terms, this is a very simple concept. You
Yes.
cannot be taken to prison before you start your case. You cannot give a judgment without having the process. More Honorable Moses Kuria's application sought to end the entire process before it began. No parties had come to court. No one has laid out their case. He essentially tried to blame Raila Odinga alone and in person
Yes.
for all the irregularities and all the issues that happened there. And without any judge having a chance to hear Right Honorable Raila Odinga's side, they were expected to give a judgment or a ruling that would have now ended the entire process. That cannot happen. We need to have all parties come to court, raise what happened, defend themselves, and if they did commit malpractices, the court will make a ruling on that after they've been allowed to say their piece. As long as you've not allowed someone to say their piece, it is not fair to then cast them out.
Yes.
At the beginning of a process, you should have the process first, then everyone goes out, considers the Supreme Court judges go out, consider the arguments of both sides, after which they come up to a decision about whether or not this side committed malpractices enough to nullify an election, or they did not, or they committed malpractices enough to have no right to have come to the court to begin
Yes.
with. But that process has to start first, and the court hearing has to be done, and then after that you give a judgment.
Pretty much. Let's look at the petitions in front of the Supreme Court. But I want to pick one again, which again raised a conversation on exactly what the weight in this particular petitions is really going to carry. Okiya Omtata's petition in particular is arguing that even did you go back and then look at the mistakes that IEBC themselves then inflicted in this election, then neither Raila Amolo Odinga nor Ruto got the 50+1. And he said, I'm going to show you that with the margins in this particular election, because it was quite a close election, that little mistakes, even if it was 10 votes, 5 votes, 6 votes, 3 votes from each particular polling station, then if you factor those mistakes that IEBC has done, whether intentional or not, then neither Raila Amolo Odinga nor William Ruto have got the 50+1 percentile that is needed under law. When you look at these petitions, and the Supreme Court is saying that we're going to consolidate that, is the weight of the matter going to be who can prove, number one, on electoral malpractices, like it was back in 2017, or indeed, we're going to look at other evidence that indeed was a factor in this election?
This goes back to the IEBC.
Yes.
Because when the counting of votes was completed, there was a total number of 1,111 KIMS kits that failed. And those KIMS kits that failed meant that the voters who were voting in those streams or polling stations had to be manually registered.
Yes.
These manual registrations is where someone would stand, hold their ID up to their neck, a picture is taken, then they are allowed to vote. This verification of these voters was not done in the same amount of time as it would have taken for the election to be announced. Okiya Omtata's argument is that when you tally afresh these manual voters, another 140,000 about, you will find that the 50 points will slowly recede down and hit 49 or 50 for one or either party which will then negate the constitutional requirement for the announcement of the election.
Yes.
So it is a curious application which the judges will have to consider, and I'm sure they will ask for the KIBS kits to be presented and the tallying to be done afresh so that we can find out, okay, there are spoiled votes, manually registered votes.
Yes.
When you put all these together on top of whatever 14.1.2 million we had counted for the total vote, if you put these guys added to that and then you retally the whole vote again, do you get the same result? Because this election was won on a razor's edge. Dr. Ruto only scratched past 50. If you add another 140,000 minimum voters, if you consider lawyer Dansan Omari's 800 disabled voters who are not able to vote because of the inaccessibility of the polling stations,
yes,
what then happens to that small margin of 0.48%? It could come down to 50, which will immediately trigger a runoff. That is Mkia Mtata's application. Yes.
Let's go back a little bit. The AG not being amicus curiae in this particular petition, could you give me the scenarios of what it is we're looking at? Under law, we've seen in the past petition, while the AG is there just to guide the processes of this particular one, the interpretation you give it, from where you're sitting this morning, what interpretation do you give it? The AG said, well, I'm not siding in either way.
The Attorney General is a public servant. A public servant is a person who works for the interests of government and Kenyans. When the Attorney General was Amos Wako, he would hold the government position, irrespective of what any other party would do. When the Attorney General was Githumu Muigai, he would hold the government position. And it is critical for the Attorney General to always be part of these proceedings. When he made the statements he made, it almost came out as a loyalist statement, saying that I will not oppose Right Honorable Raina's application in court. This is almost a dangerous statement, if I was to say so. Because irrespective of what happens, if
yes,
Dr. Ruto was to come into office, you can read that the Attorney General will have to change. If the other side was to come to office, you might find that the Attorney General has a lateral movement he wanted to do. So he has no losses in saying, let me not do anything, let me stay out of it, and let's see what happens. So that if Dr. Ruto takes the day, I was leaving anyway. If Azimio takes the day, I can now argue I stayed out of it. So this is what you read into it, and you know Kenyans, we like to speculate. So
yes,
we would have preferred a situation where the office of the Attorney General is treated the way it should be, not as a loyalist place, but as a place where, irrespective of any issues that or any waiting time that the Kenyans are waiting to know who the next government is,
yes,
the government position is held and stated in court, because
yes,
the president is still in office.
Yes.
Until a new president will be sworn in, there is a president in office. There should have been someone in court from the Attorney General.
When you look at the petition in 2017, when we did have the AG in court actively guiding the court on the position of the government in that particular petition, would you say that indeed, to a certain degree, it did influence the ruling that the Supreme Court made in 2017? Because other guys are saying, well, whether is there or not, still the court will go back and rule independently despite what it presents at the Supreme Court.
I think we all need to know that the judiciary is independent.
Yes.
And independent beyond any reproach of any other institution. The human rights activist who was the Chief Justice, Dr. Willy Mutunga, was known to go against all government positions through his tenure. Yet, at his presidential petition in 2013, he upheld the election. Gone against the grain of who we knew Dr. Willy Mutunga was. He was acting independently of the executive. When you are looking at 2017 presidential petition, Dr. Maraga went through a lot. He even won a press conference saying, we have no budget to run this government, to run our judiciary. However, when it came down to whether or not he would have to nullify an election, he bravely took the stand and nullified an entire presidential election.
Yes.
The same will be seen of this. If there is a presidential election to be upheld here, Chief Justice Martha Koome will do so. If Kenyans are required to just go back to the vote and have a runoff, which is what we agreed as a constitution would happen, she will make the brave choice.
Yes.
And Kenyans will respect it. As you have seen from before the constitution was promulgated in 2010, our ways of dealing with presidential results was maandamano, to say the least. Every time we do an election, we want to go to the street and say our piece.
Yes.
But since the Elections Act and the IEBC Act and the presidential petitions rules were all passed, Kenyans seem to have an understanding and a faith and a trust in a judiciary that will audit an election, look at both sides of all parties and what they have said, and come up with a ruling that everyone will not be happy about, but will respect.
IEBC now finds itself at a very interesting position. They're in court again, challenging a petitioner from IEBC. That's how we're looking at it right now. Somebody said that indeed what IEBC should have done, and with Chebukati in person, is to go back in 2017 and look at that ruling for the Supreme Court, sit with the particular commissioners that he had, in spite of the time that they came into the office, and say, look, this is the ruling from 2017. Can we go back and tick all these other places under that ruling? Essentially saying that indeed, if you tick all these places, according to the law, you will be presenting a free and fair election in the face of Kenyans and in the face of the courts. Because indeed, those questions that were asked in 2017, by the way, again, are the same ones that are getting asked in 2022, understanding electoral law and following it to the latter. Is that a failure of IEBC, really? And do you think that going by the ruling in 2017, really, they went back and ticked all these places and said, guys, we got to deliver it free and fair, so let's go back to 2017. We have a blueprint to follow.
When you look at 2017,
yes,
the main gist of the judgment by Chief Justice Maraga and his 5 other Supreme Court judges, because there was one less that time, Swokin Wanjala, who did not participate, they put the core reason of why they had to nullify an election being the IEBC have refused to open their servers. They are saying their servers are in France, they cannot access them. What Chebukati and his other 2 commissioners, you remember they've been doing this alone for 4 years, preparing for an election. Election season was already upon them by the time they were given other commissioners to work with. They worked and made sure the portals and the servers for this election cycle were open, so that every result as it comes in provisionally or officially, Kenyans are aware on the fly, on spot, they are aware of what is going on. Yes. The issue of provisional results being announced before the official results, they refuse that issue as well, rather than getting a phone call to be told this is the election result in Nyamira, this is the election result in West Pokot. They would wait for the Form 34As, all of them to be collected and brought all the way back to Nairobi, verified afresh, and after that, make the announcement, which is why you were seeing announcements stretch between 3 to 4 to 5 days after the election was done, because it will take a lot of effort to finish counting 20,000 votes in Wajir. Yes. Put someone in a vehicle, safely transport that. Those results back to Nairobi, hand over those results, and then verification is done. So you cannot put it all on the IEBC. They did their part. They are evolving with each election, so that the issues that were there in the last election that caused the election to be nullified outright are not there this time. The issue of the servers, open. The issue of verifiable results, done online, done in person, while after the commissioners have received the results. Yes. The new issues about hacking of the systems, the new issues about the
alteration of Form 34.
Alteration of
yes.
forms.
Yes.
This is not a creature that was seen as the main issue of the last election. It is seen as the main issue of this election. So that now the judges will have to pronounce themselves on, okay, the timelines of the election are this, you should do this, that, and the other, so that the IEBC will now take the fresh jurisprudence that is given to them on the errors that were made, because we all agree there were errors made.
Yes.
We only don't agree on whether these errors were enough to nullify an election. You see, so 2013 we had errors, but they did not nullify.
Yes.
2017 there were errors enough to nullify.
Yes.
So we always have to audit an election after, if there is any issue, to see whether or not the process was so free and fair that the small issues that occur, because in every place in the world, even in the USA, you would see one presidential candidate saying they stole. They stole the election. And I've never. To date, 2 years after the election ended. The other side, the country moved on without, irrespective of what was happening. Yes. But they still audited that election and moved past it. The same thing will happen here and in every other democracy on the planet.
Yes. The interpretation of the law, and that's one thing that really Kenyans are looking at, even when we're looking at these petitions. Let's begin. Number one, IEBC is mandated under the Kenyan law and the Constitution to deliver a free, fair, and credible election. Some of these petitions are challenging that this election was not credible on the basis that we can actually prove that somebody hacked into the system. No matter how little, because even the proving process might not be 100% accurate. That's exactly what we're saying. On that basis, are we going, does the law look at it in totality? That look, in black and white terms, it's supposed to be free, credible, fair. Guys, it's not credible because we can prove, or somebody has proven right here, right now, that your system was hacked. Does the law also consider other factors, or the law operates in black and white terms? Guys, it's not credible, so you gotta go back.
All factors have to be considered in a case. Whether or not you were hacked, we need to also know what was the consequence of these hacks. Were they able to make any changes or any alterations? Because again, we have manual documents for Form 34A, right? At the polling stations, there was a presiding officer who signed a document for the votes. There is a chief agent for each presidential aspirant who countersigned those documents. And those documents were carried from polling station to the county returning officer, from the county returning officer to Nairobi. So you might say that they were hacked, yes, and while the counting was being done online, things were not the best. But you will also find that when the manual receipts are brought to book, they can correct the hacking issue by saying, we order retallying using only the manual Form 34As. That would be able to correct that. So do not look at hacking as such a critical consequence that it would throw an entire election up in the air. The IEBC does both manual and electronic vote counting, so that when one fails, and electronics have been known to fail persistently all over, as you have seen with the 1,100 and so forth,
yes,
Kimskets. There is the secondary counting of votes that was done in the polling station in front of all agents, and where forms were signed and countersigned by those agents present at the polling stations. And those results were brought to Nairobi.
Yes.
So there will be a situation where that if they do sign that the electronic systems failed for hacking or whatever other reasons, or there were blackouts in part of the country where Kenya Power do not care for Kenyans, then we'll find that the manual receipts will be brought, a retallying will be done, and you'll be told how did they hack the manual receipts after that. You will not be able to prove anything beyond that. So a retallying can be done with manual documents of the Form 34As, which were at the polling stations and countersigned between IEBC officials,
yes,
and officials of the political parties.
Yes.
Yes.
Electoral law, again, that is exactly what we saw again in 2017. Like, could you interpret what this really means? Good. This year, that special focus there on the other commissioners really dissenting from Wafula Chebukati's result, which is again, is carrying weight in one petitioner, that is the Azimio coalition. Whose responsibility is it to interpret what the law envisions you as a commission to do? Because that's also going to carry weight in this petition that we're seeing here from the Azimio coalition, in the sense of, who is IEBC? Let's begin from there. Who is IEBC?
IEBC is a constitutionally mandated institution.
Yes.
IEBC is not a person. People will come into that office and they will leave that office. But the institution of IEBC is the electoral body of the country. Right? The 2017 election audit, there was a Kriegler report that pronounced himself on that issue.
Yes.
That IEBC commissioners, especially on the run-up to an election should be in office, appointed, and ready to serve 2 years, minimum 2 years before an election. He is run. This was as a recommendation until now. I would like to see a situation where when the 13th Parliament is sworn in, they take that recommendation, put it as a bill in Parliament, pass laws to make sure that if in the event the second year towards an election is arriving, the Parliament is allowed to appoint, irrespective of president or anyone else who is meant to appoint, so that as because you can see, like, for example, the Parliament right now has yet be sworn in. But the law, as it stands, will be on the 30th day from the election results being announced. If the president has not called Parliament to swear it in, the issue will be deferred back to the Speaker, who can call Parliament and swear them in himself.
Yes.
Right? This is a timeline, in a time frame where, at the end of it, it will be done irrespective of who is in office or who has the power to do so.
Yes.
So if they were to do the same with the IEBC, take the recommendations of the Kriegler report, put it in Parliament as a bill, you could now set a time frame where the Parliament could debate, agree, and appoint commissioners and confirm commissioners rather, and the appointment process will be on the second year towards an election, irrespective of any appointment from the presidential level. They will be confirmed.
Yes.
And start working in office, irrespective of anyone else's issue.
Yes.
So that if that fails, then you will now know that there is no constitutionally mandated IEBC, and you'll start affecting the timelines for the next election.
And how heavy is that argument? Because we've seen Azimio Coalition has that, it's saying, guys, should you give it our way? This IEBC that we're looking at right now, with the way it is, we do not have faith in it. You also got to go back and give us a guideline on how we're going to constitute an IEBC that can run this particular election. Then it carries weight, that particular argument, because it does, going by the facts that you're giving out right now. And then if we start then respecting these timelines, what are we staring at?
You may not like the IEBC that is there.
Yes.
But it is the IEBC that you have.
Is that what the law envisions, isn't it?
As long as Chebukat is still constitutionally in office for
Yes.
the 6-year term, which does not end until January 2023, he is in office validly, and he is the one who will run the runoff, if that is the case that is to come. Irrespective of whatever rulings the judges at the Supreme Court make, we have to have an IEBC. There is no parliament sitting now. The Supreme Court is unlikely to disband an IEBC and force Kenyans to run a country under a president who is not constitutionally in office. They will most probably, at the tail end of this, either confirm the presidential results and ask the next government, recommend the next government to correct these areas.
Yes.
So that the parliament that comes in next, with the government that's running the next order of business for the next 5 years, will be given recommendations on how this will happen. And if they do not correct that, they will face the crisis in 5 years. And government will listen.
Yes.
As it did in 2017.
Yes.
If the presidential elections are nullified, there's no situation where you'll find the Supreme Court has fired IEBC from office. They will still continue in their mandate and told, go correct this, that, and the other, and then come back in 60 days to run an election.
Yes.
That is what's likely to happen.
Pretty much. All right, let's look in entirety then, Mugaka, what we expect from the Azimio coalition. What is the weight that the lawyers of the Azimio coalition have in front of the Supreme Court? If you look at that petition, what is it that they have to prove? And if you look at the affidavit that has been applied also by Ruto, what does Ruto have to prove in front of the Supreme Court? What has to come out clear for that case for Raila Amolo Odinga to stand?
In legal proceedings,
yes,
I always feel that it is much better to be the respondent than it is to be the petitioner. Because the standard of proof and the weight of the buck falls on the petitioner to bring all their evidence, and the bar is set very high to prove that whatever conduct of elections was occurring was so egregious and so irregular and so full of malpractices that the entire system has to be torn down just for me to get another election chance at a runoff. So you'd find that Dr. Ruto does not have much to prove. All he has to do is defend the position of the announcement, whereas the team for the Azimio has to find irregularities in the hacking, irregularities on the ground, malpractices from point A to point B, prove that the bribery scheme was so extensive that it was inconceivable that a fair election could be had. They have to prove that the IEBC's division after an election had already been conducted was so egregious that their split can cause an entire country to stop. It is a very high bar to prove those issues. So you would always like to be on the side of, we have announced a president-elect, we just need you to confirm it, versus you have to go through the constituents, you have to go through the computers, you have to go through the paperwork, you have to go through that lorry you brought to court to be able to establish that an entire election has to be overturned for you to go and do a runoff. So the respondents, Dr. Ruto and the rest, I know they're sitting pretty. They are just making sure they are organized and putting their ducks in a row to defend the position of the election, but they are not doing as much as an audit as the side of Azimio have to.
So the weight, the back end falls on Azimio to prove.
The back end of this entirely, almost, falls on Azimio, to prove that an entire presidential election has to be nullified when everyone who is governor, MP, senator, and MCA stays in office. To just nullify one election versus an entire general election, there's a very high bar set for them to prove that case.
Other sides that are arguing like this, that in a tight election then, it will be easier for you to prove that the election was not credible, because then for that election to be stolen, you don't need to steal so much. That does take some weight off the Azimio petition, knowing very well that even if they get 1,000, even if they get 10,000, even if they get 100,000 votes that were not well given for by IEBC, then it does put the 50+1 percentile into question.
You find that there are very many prayers
on
the 9 petitions. Some want a retallying of the votes. Some want an entire nullification and a presidential election run afresh. Some want just the bare minimum of 140,000 votes taken out so that we have no constitutionally appointed president. Everyone has come with their own argument, and once the court has consolidated all these affairs, they'll be able to decide on which of these has merit. But they had to come from all sides and file their petitions and bring their arguments to court. And the ones that were weak on the face of it, as you have seen, have already been pulled out, so that we can now have less baggage on the court to make these decisions. But the court will be looking at every angle. Do we need to just count the votes again and agree? Because the rest of the general election seems to have gone pretty smoothly. Is it that there was system deficiencies that are so egregious that we have to nullify the election and do the presidential election again? Because again, this is very different from a runoff. A runoff would not require anyone hitting 50+1%. It will just be the winner takes all on a runoff election. Whereas in a nullification election, the same constitutional mandate is required, where 50% has to be acquired from 25 counties. After that, you get the 1% extra. That is what happens in nullification. In the event that we are doing a runoff, it will be winner takes all. So there are 1, 2, 3, 4 different ways this could go, and the judges just need to consolidate all these affairs and now listen to everyone's side. Do you want us to nullify and you go start again? Do you want us to declare that there is not enough and you need to go do a runoff? Do you want to declare that the entire general election
has to be,
that was done in Kenya was completely fraudulent, and we need to go start a general election again? We start campaigns for another 60 to 90 days. Everyone needs to come with their argument, and the court will just sift down to the most important issues, and from there give you a judgment on what.
Just before we go back to how we conducted the petition in 2017, where we did see former CJ Maraga saying that, well, the weekends are off for the Supreme Court. It did not really come for the sanctions over the weekend. Let's go back a bit again. The Supreme Court has said that we're going to consolidate the petitions that we have at the Supreme Court now, just to make our work easier then, which again, when you look at it, then takes off the back the weight of the Azimio Coalition's petition, saying some of the factors that we cannot prove right now succinctly might be proven by the other petitions that the Supreme Court has already said that we are going to consolidate. Does that give weight to the Azimio Coalition petition further in this case?
When you look at former Chief Justice Maraga, they may have taken the weekend off, but they did come up with a summary judgment before they gave the full reasoning for those judgments on the date that they were required to do so. So in the fact of whether or not the judges have enough time, they have plenty, including weekends, which they take off, because they are also human beings who need to rest, recharge, and consider the thoughts and suggestions of everyone on their own speed and time. They will be able to give, at the bare minimum, a summary judgment on that date, on all issues that are being raised at this point. Because when you're looking at an election,
yes,
it is only a one-day event between 8 a.m. to 5 p.m. Election petitions for governors, MPs, and senators will carry all the livelong day for the next 2 years.
Yes.
Right? You are seeing in the previous election someone who 2 years into office was being kicked out because the petition was proven by the other side, by the opposing side. But the presidential election, with 7 judges and a full battery of lawyers,
yes,
law clerks, including judges including even the former Chief Justice of Tanzania, who is in Nairobi to observe, there are a lot of people who are giving a helping hand to the Supreme Court to come up to the right decision in good time.
Yes.
So all the things you want to throw at the judiciary will take, it will absorb, it will react, and it will give you responses. Within the timeline of when Moses Kuria had filed his petition, it has already been adjudicated upon and thrown out for a lack of relevance to the presidential petition. You will find that the judges are working around the clock, not just themselves. They have law clerks under them. Under law clerks, they have regular court clerks. Under the court clerks, there is the lawyers from each side who are assisting them by giving them all the relevant information, where all the judges have to do is just read, think, react. So by the time they are doing this system is so efficiently running that on September 5th, you will have a reasoning on all the issues.
Pretty much. So let's also look at it wholesomely in this sense as well. In the last petition in 2017, we had one judge who was missing out of the bench. Yes. What is the outlook of having the 6 judges then come out to give their ruling on this particular case?
We were almost in a constitutional crisis last time.
Yes.
Because if we had found ourselves in a situation where there are 3 in support and 3 against the previous election, we would have been in trouble as a country.
Could you put that clear? What trouble will we looking at, Mogaka?
When we have an even number of judges,
yes,
and every judge's votes count, there will, in a situation where all judges react equally and divisively, 3 on the left, 3 on the right, and no one abstaining, you would have found a situation where there is no decision in this country. The reason the Supreme Court is comprised of 7 judges is that irrespective of what happens, there has to be a majority vote in the Supreme Court so that the majority vote can carry the day. Failure to have this, like in the last election, would have required all of us to sit in our houses and wait for Smoking Manjala to come back from wherever he is to come and break the tie after the fact, which is what should never be a situation our country should be in. So as we are with the 7 judges today, we are in very good hands. We should expect that once the judgments come out, there will be a majority decision in the Supreme Court, and that majority decision, whichever way it lands, is what Kenyans will use to come to terms with whatever happened in this election.
Yes, pretty much. So it speaks to how we've grown as a judiciary. And I'm asking that question going by exactly what we've seen has been going on in the judiciary in this country, where we have the executive and the judiciary sort of at loggerheads on certain critical decisions, something that even really did not settle well with the former CJ Maraga, especially when he was stepping out of the office. When you're looking at the judiciary right now, in this country as it stands now, you will say that in the top court, that is the Supreme Court, that in terms of sitting well, that they do understand that currently, as it is, they're allowed to run their affairs.
Yes, they are. The situation might not be easy. We do not have a government incumbent this time that will have a reaction to our decision. We have a government incoming for the first time. So whatever decisions the Chief Justice and the Supreme Court judges make, they can make free of the idea that whatever decision they come to, they will be punished for it, because there is not yet a new government. So they can come to this decision, first and foremost, as free-spirited people who are going to do the work of Kenyans. But secondly, the judiciary, by the time you get to a Supreme Court judge, is very independent and very brave. And by the time they choose these appointments and they start their terms, they are aware of their mandate and their responsibility to the Kenyans, which is their first and only role, to make sure Kenya as a country survives every election, and not only survives, but thrives going forward.
Yes.
So they will take care of us, as they should.
As we come close now to the end of this conversation, I know there's something that you're looking at in these petitions that have been presented to the Supreme Court, and you're sort of looking at it and saying, I may want to see how that plays out. Could you point one of those issues that you're looking at these petitions, and what do you expect, or were you waiting then to see what the outcome is going to be as regards the petitions I've already seen?
I would like to see how
Yes.
these political parties are organized, because it seems to me that William Ruto and the Kenya Kwanza outfit have had 4 years campaigning on the road together to organize, gel, and distribute all their affairs and responsibilities, from the ground polling clerk to the presiding chief agents,
Yes.
to the legal team, who are always ready for whatever outcome would come,
Yeah.
versus Azimio, who are a collection of very many parties who came together late in the game. Azimio have a very long task ahead of them. They have to find a way to work better than a Manchester United team that started this season. They have to show up to the ready to play like a Champions League outfit.
Yeah. Be safe so you don't play into the Tumejipanga Sisi's idea too.
I am not playing party politics here. I'm just hoping that outside of the legal expertise, which is going to be top-notch on both sides, the messaging coming out of Azimio needs to be in unison, needs to be one. They need to be guided by the presidential candidate and his statements, which should trickle down to everyone below him, so that when we are dealing with a petitioner, Azimio led by Right Honorable Raila, they are able to hit back in as organized a manner as Kenya Kwanza have been doing for the longest time. So I am waiting to see how much of a voice, or one voice, Azimio is going to have in this presidential petition.
Pretty much. Elkanah Magaka, thank you very much for coming by.
Thank you so much.
You've been quite instrumental in understanding exactly what it is that we are expecting then today on that particular conference by the Supreme Court. Issues that are going to be discussed. Number one, they're going to look into the number of lawyers they're going to assign, its side, any orders that we're going to follow. And according to Elkanah Magaka, he's saying you're going to see some sort of discipline in the way they're going to carry out this particular sanction as from tomorrow all the way up to Monday, when we expect that they will come out with a verdict concerning these petitions that are challenging the 9th August elections. Guess what? It doesn't stop there. We're still here, because what we do know, we are going to take you live on those sanctions, but we are building up onto it. Next, we do have another conversation, another aspect of these petitions that are at the Supreme Court. So more reason for you to hang around. Join us online and look up TV across all your social media platforms. I am Ankey Simba. We come back shortly.